Progress. All right. Hello, everyone. Hey, I'm Whitney Petrelli. Thank you all so much for being here tonight. We're truly grateful that so many of you, so many familiar faces are in the room. Whether you've worked together or you're supporting us through referrals or connections, your trust means a great deal to us. We're not just your local realtor. We are neighbors, your advocates, and someone who's deeply invested in this community. So in real estate, we believe it's about more than just buying and selling homes. It's about building relationships and helping people protect what matters most. That's why events like tonight are so important. Over the years, we've seen firsthand how having a solid estate plan, especially tools like living trusts, can make a huge difference for homeowners and their families. Our goal as a realtor is to continue being a reliable, value-driven resource, whether that's connecting you with the right buyer, helping you understand your home's value, or like tonight, introducing you to experts who can help you plan for the future with confidence. So again, thank you for being here. We're excited for what you'll be learning tonight. And if there's ever anything we can do to support you, your real estate or otherwise, please don't hesitate to reach out. So now let's dive into the important stuff for conversation with our expert speaker tonight, Daniel Leonhardt from American Family Estate Planners. So welcome.
Appreciate y'all coming this evening. My name is Daniel Leonhardt, and tonight we're going to talk about how wills work and how trusts work and how they're different. What's probate? How do we avoid the probate process? What triggers a probate here in Virginia? We'll talk about what happens if you don't have a plan. You know, the I'll get to it someday plan. What if you die with just the last will versus a revocable living trust? What's the outcome to your family if you do this versus that? So we're going to lay out the different legal options that we all have. I always remind people we can't make good choices if we don't have choices. So my goal today is to let you understand sort of the options that you have so that you can make the right decision for your family. It's important. A lot of over the years, people have asked me, well, Daniel, what is estate planning? And I usually start by telling you, well, let me tell you what it's not. Estate planning is not financial planning. Financial planning, you know, is investing in growing your wealth. And eventually, after you do some financial planning, it turns to retirement planning, where you say, I don't want to work forever. At some point, I want the money to work for me. I want to stop working. So that's, you might change some of your investments for that, but that's not at all what we're talking about tonight. Estate planning is sort of the third level of planning, and is really basically just making sure that all the things that we've accumulated in this world go to the right people at the right time without fighting, without courts, without the probate mess. That's the goal of a good estate plan. Now, I know that we all have wishes and wants. You know, I don't want my kids to fight, or I don't want my son-in-law to get anything. I like to remind you folks, what you want and what you get is going to vary based on what you do. We have the ability through great documents to orchestrate this. So let's talk about options. Some people's estate plan consists of this. Every year you say, well, didn't do it last year, I'm going to do it this year, until next year when you say it again. And it's just a series of kicking it down the road. You know it's important, but you never quite get to it. Well, if you die without a plan, and I mean no will or no trust, that is called dying intestate. And folks, when you die without a plan, you do get a plan. It is called the government plan. And the state in which you die, in this case, the Commonwealth of Virginia, is going to create a will for your family after you're gone. Now, this new government written will has to go through a legal process called probate, where the assets will be tied up in the courts, and the family has the opportunity to get together and argue over the things you left. Folks, there are two things that I am pretty sure you do not want. You do not want to send your family to court, and you do not want the government to write your will. Now listen, when the state writes the will for someone who died without a will, the state does not know any of the family details. The government doesn't know that Susie already got her inheritance, and Jimmy hasn't talked to Dad in 10 years, and Barbara never paid back those loans. But you know who does know the family details, folks? The family knows. So when they get together in the courtroom, it sometimes sounds like this. Your Honor, yeah, this will you guys came up with? Not even close. She shouldn't get, he already got, Mom wanted me to have, and guess what they wind up doing in court? is they wind up fighting. And do you know who wins that fight? Besides some local attorney and the state, who often wins that fight is just the person that hired the better attorney. You know, Jimmy, the more clever son, hires a good lawyer. And when it all shakes out, Jimmy winds up with more of the estate. The worst part about this plan, the do nothing plan, is very often the end result is that they just don't talk to each other anymore. And I'm sorry, sometimes that lasts for decades because of what she got away with or what he tried to get away with. I will admit to you, the do nothing plan is the least expensive plan available for you today. But it is not the plan you want. It is the plan that will cost your family the most time, money, and aggravation. So I would make a commitment, not to me, but to yourself, that I'm not going to leave this earth without something in writing. I need to have a plan at some level in place. So make that commitment to yourself. Okay, that being said, what can I do to prepare for my eventual departure? You could do something called a last will and testament. Now, everybody's heard of a will, and some of you may already have a will. Let me remind you what a will is. A will is basically, folks, a set of instructions that says something to the effect, when I die, I want these things to go to these people, right? It's a distribution document. But what you may not know is your will, when you die, has to go through probate. Whether you write the will or the state writes the will because you didn't, wills have to go before a probate court and a probate judge. Now, I'm gonna mention the word probate a few times this evening, and I thought you might want to know where the word came from. Even if you don't know, I'm going to tell you. The word probate comes from an old Latin word. The root word of probate is the word probare. The word probare meant to test, to prove, or to challenge something. Well, what is being tested or challenged in the probate court very often is the will itself. Someone doesn't like what mom wrote, so they come in, they can challenge the wishes of the deceased. Now, when someone challenges a will, they have to get the court's attention. They don't say, Your Honor, it's not fair. I'm not getting what I thought I was going to get. They usually try to get the court's attention with some sort of angle of attack. And they might say this, Your Honor, that doesn't look like Dad's writing. I know that's not what Dad wanted. I think somebody drew this up after he died. You know, we took weeks trying to find a will, and then this popped up, you know. Another angle of attack might be this, Your Honor, Mom was saying all kinds of crazy stuff at the end. I don't think she was mentally competent to draw up the document, you know. She was not of sound mind, you know. Another one might be this, Your Honor, all of my life I was told I was getting this property. I saw a will that says I'm getting this property, but this new document shows up. Suddenly everything is going to her. I think she talked Mom into changing it. And the term you might hear is undue influence. She was the caretaker, you know, the one in charge of food and medicine, and suddenly things change in that direction. Very often it's the second wife, where the kids were always told the vacation home was going to them, and then a document appears and it's not going to them, and they're surprised by that. Bottom line is this, a will is a set of instructions, but it is not binding. Wills can be changed. Wills are challenged in courtrooms all the time. A will, by the way, folks, does not help us at all if we become incapacitated prior to death, whether it's Alzheimer's or dementia or a massive stroke. Because, folks, a will does not go into effect until you are dead. So a will is certainly an option, folks, but it is a very narrow option. It only deals with distribution after you're gone. It doesn't help you while you're alive. It doesn't avoid the probate process. It still has to go before a probate court and a judge, and it can be contested. There is a much better option that's available to all of us. It is called the Revocable Living Trust. The Living Trust, folks, is a legal document that allows us to transfer our assets to our heirs when we die, but it does so without courts, without probate, without delay, and most of the time, if you do this right, without any of the family fighting. Because unlike a will that can be challenged and argued about, the instructions in your living trust when you die are binding. When you create a trust for your family, you are in essence saying, hey kids, here's what you get. Now, whether you like it or not, that's optional. You can be happy with what you're getting or not, but you are getting this asset or this percentage or this property. It is not subject to debate. The instructions in your trust are binding at your passing. So when you die, the instructions are set. The trust, folks, not only makes a smooth transition of our assets to our heirs when we die without courts and without government intrusion, the living trust does take care of us while we're living, because in the living trust are what we call incapacity documents. Now, think of the trust portfolio as that. It's a series of multiple wishes. Certainly, it will describe what I want to have happen to the assets when I die. That is part of the trust. Who's going to get, who's going to distribute, how much is going where. But also in here are these other documents dealing with incapacity. So again, it is a portfolio of multiple wishes. If you are a married couple and we were to make a trust for you, we would likely make a single trust. Not that we have to, but usually it's one marital trust for the two of you. But within that marital trust are separate documents. You don't have to agree with your spouse on who will care for you. So let's go over these incapacity documents, which are part of the trust portfolio. Everybody's going to get a power of attorney over financial and legal matters. That is called the general power of attorney. And that is basically, who do you trust with your checkbook? If you're incapacitated physically or mentally, who do you want to grab the checkbook, pay your bills, have the authority to do that? They will also have some legal authority. If you're rattling around a big old house, leaving the fire on because of, something's not all together here and the family's freaked out because you're going to burn the house down, they would have the legal authority to also help you sell and downsize. So there's some legal as well as financial authority you're giving to this person. There's a second document called the power of attorney over healthcare or medical power of attorney, sometimes called healthcare proxy. And that is, who do you want to interact with the doctors? Consent to surgery. I will remind you, if you're unconscious, you cannot consent to anything. So someone has to speak for you, and you've selected someone to do that, the healthcare power of attorney. The power of attorney for healthcare can be the same person that is the power of attorney for financial, or it could be somebody different. They are different roles. There's a third document in this group, and that is today, it's called the living will. A living will is not a last will, and it's not a living trust. Today, the living will is usually called the advanced medical directive, and that doesn't deal with who, but how would you like to be treated if you're on life support, feeding tube, respirator. We heard the word ventilator too much in the last 5 years, but the reality is, if you're in those circumstances, you cannot direct anything. So the direction has to come in advance, advanced medical directive, right? You're saying, if this, then here's how I want that played out. Does that make sense? Now, some of you in this room, this is a young crowd, but some of you might remember the name Terry Schiavo. Was a girl in Florida that had a terrible accident in her late 20s. And she was in what we call a vegetative state. She was not in a coma. She was in what we call a vegetative state. She couldn't interact. She couldn't feed herself. She had a feeding tube. After a while, her husband said, Terry wouldn't want to live like this. We're going to disconnect the feeding tube and say goodbye. Well, Terry's parents said, hold on, we think she's still there. When we come into the room, she sort of lights up. So what happened? They went to court. And in court, as you probably know, there's a winner and a loser, and the loser appeals and they go back to court. And if you don't know the story, they went back to court and back to court and back to court for 15 years, all about the feeding tube. Do you know who eventually decided her fate? State of Florida. They finally said, that's it, we're not going to court anymore. The state says this, and that's what they had to live with. The reason I tell you that story is simply this. It's not because Terry had no wishes. It is because Terry had not expressed her wishes in writing in time. I'm going to say something. Terry might have been adamant. I would never want this. I'm going to say something that's really true, but it's also a little blunt. And here it is. It's not going to matter what you want. It's going to matter what you wrote. Did you get your wishes in writing with witnesses and notaries? Very important stuff. So part of the trust portfolio is also taking care of you while you're still here on the earth. Now, I like to break words down. Probate comes from the word probare, to test, to prove, or to challenge something. The phrase power of attorney, the word power just means authority. I'm authorizing you, I'm empowering you with my checkbook to care for me with my money, but I'm giving you that authority. The word attorney in power of attorney does not mean someone that went to law school. It just means advocate. Now, in a courtroom, you hope your advocate went to law school, right? But in this circumstance, it's typically going to be a family member. Now, I happen to have a choice that many of you in this room have, and that is I'm a married man, been married to my lovely wife, Christy, for 40 years. I am her power of attorney for financial and healthcare, and she's mine. Does that make sense? We've selected each other. But what if my wife and I get into a bad car accident, and in the accident, I become impaired, but she dies? I now need a power of attorney. I'm impaired, but the person I selected, unavailable. In that scenario, I not only lost my wife, but I lost an important part of my estate plan. My power of attorney is gone too. So my point is, when you name your first choice, that is my primary choice, always name alternate A and alternate B. Why? You have no guarantee that the person you want will be there. They could be in worse shape than you. So pick a first choice and then think alternate and alternate to the alternate. I happen to have some pretty good choices. I have 4 adult children. I've got a daughter that can tell you how much money she has in every account and how much she's saving for Christmas. She's married to an accountant. She's good with money. So if I cannot be there for Christy or she cannot be there for me, she's the one it drops to next. I have another daughter that's a nurse practitioner. She wears scrubs and works in a hospital all day with doctors. So when it comes to medical power of attorney, she's the next one after each other. It drops to her. If a doctor were to say to my daughter, hey, I need you to sign here for your dad's surgery, you know what she'd say? Well, hold on, let's discuss this. There are risks with surgery. What is this hospital's percentage of success rate with this procedure? What is this doctor's percentage of success rate? You know why? She works with doctors and she works with good doctors. She wants to, I'm looking for someone that would ask the questions that I would ask. I am not looking for someone that just says, where do I sign? So I'm looking for an advocate, hence the A word, right? An advocate that would act like me, ask what I would ask, want to know more details than just that. I've had over the years, people ask me, tell me, Daniel, I don't have a nurse or a doctor. Who should I pick for the healthcare? So, well, first of all, that choice is yours. They're your heirs, but your children. But I often say, well, think of somebody that's good under pressure, because sometimes that job is a difficult job. The doctor says, we need to know in the next 15 minutes if we're going to do this. That's pressure, you know? Sometimes they have to make the ultimate decision to say goodbye and disconnect. And that's pressure too. Sometimes the family's barking in their ear. You're not going to do that, are you? And you know what I want them to say? I'm going to do exactly what dad instructed me to do. You know, dad picked me. He also gave instructions. Now, I might not even like what I'm going to do, but I'm going to do what he instructed me to do. That's what I'm looking for as an advocate. Someone that won't just keep me on because they can't make that choice. And I'm there year after year, month after month. Why? Because they didn't do what I asked them to do. So I'm giving instructions, but I'm also picking people that will follow them. Does that make sense? Right. When it comes to the money one, look, I'll just say this. If your son is bad with his money, he'll probably be bad with your money. So you have to think into these terms. Who's willing? Who's got the aptitude and the willingness and the skill to do that job? You might have limited choices, but the point is you need to make the choices and not let them make the choices. So this is all really important. Now, a lot of people have heard that a trust avoids probate, and that is true. But not everybody's sure they know what probate is. I mean, they know they don't want it, you know, but what exactly is probate? Well, folks, probate is a judicial process where when someone dies, the state through the courts, they have to verify and validate any wills or instructions that you've left to see if they're current, you know, relevant, up to date. They have to settle family disputes. They have to pay the debts of the deceased. And when all of this is over, eventually assets do get distributed, but that's at the end of the probate process. There are 2 major misunderstandings about probate, so I want to address those. Here's the first misunderstanding. Some people think, now they're wrong, but they think that a will gets you out of probate. And the logic is simply this. Well, I've written down what I want and it's signed and notarized. And I say, that's wonderful, but it still has to go to probate. Now, there's a couple of reasons why. Well, there are many reasons why, but I'm going to give you one reason right now. A will does not always represent the wishes of the deceased when they died. Now, we assume it represented your wishes when you wrote it, right? I want this, and this goes here, and this person acts like. But after someone writes a will, sometimes things change, and people change their mind. I had a guy come to my meeting once. He said this. He said, Daniel, I do have a will. I wrote it 15 years ago. He said, the will gives everything to my wife, Kathy. He said, now the only problem with that is I've been married to Susan for the last 7 years. Because Kathy was my wife 15 years ago. She is now my ex-wife. I said, and according to this piece of paper, the beneficiary of your entire estate. You know what the legal term for that is? Whoops. I had someone come to my meeting not long after. She goes, oh my God, you just reminded me my ex is still on some of my accounts. I was busy getting divorced. I forgot about that. People have out-of-date wishes. And if you don't clean it up, somebody else does after you're gone. Maybe to your liking, maybe not. Now, the second misunderstanding, again, the first one is some people think a will is enough. No, wills have to go to the probate process. The second misunderstanding is that some people think they don't own enough. And they go, well, maybe rich people have to deal with that, but I just have a house. It's actually a modest house. I got 2 kids, a pretty simple life. You do not need to be wealthy to trigger a probate. Now, I use the word trigger because it's a dollar amount. And the amount that triggers a probate if you die in Virginia is different than if you died in the district or if you died in North Carolina. And basically the states set a dollar amount. And they say, if you own less than this amount when you die, your estate skips probate. But if you own more than this when you die, your estate triggers the probate process. Well, here in the Commonwealth of Virginia, that dollar amount is $50,000. So your homes are worth multiples of that. Even a lousy home that is going to be worth multiples of that. So it is an incredibly low threshold. By the way, if you were to move to North Carolina, the number is 20,000. Most of the cars on the highway in North Carolina are worth more than 20,000. The district, it's 40,000. What can you own in DC for $40,000? I don't even know. A parking spot, maybe, I don't know. But it's an incredibly low threshold. Now, over the 20 some years I've been doing this, I've had people say things like, Daniel, that number doesn't sound right. I think I remember it used to be like 650,000. Then it went to 675,000. Then it went to like 1 million. And I said, I'm sorry, but that is never what triggered probate. But that used to be, back in the 90s, what triggered federal estate tax. That's very different than probate. If you don't know what federal estate tax is, it's something like this. The government says you died with too much money, but don't worry, they're going to help you out. And they just start taking your money. Now, once you hit the threshold for federal estate tax, anything over that is usually taxed at 40%. That's a lot of money you're giving to government so they can give it to Peru or somebody. My point is this, once you hit the threshold, the tax is pretty hard. Now, 2000, it went from 675 to 1 million. A few years later, 1.5 million. Then it went up. I'll tell you what, 2010, that was the year to die, folks. There was no federal estate tax for 1 year. That's the year that Steinbrenner died and gave the Yankees to the family, no tax. Good timing. But the next year it came back at 3 million. Anything over that would be taxed. It has eventually climbed 3, 4, 5, 6. Today it's 14 million. So I'm going to assume most of you in this room are just under that. You don't own enough to trigger federal estate tax, but you do own enough to trigger probate. Are you with me here? 50,000, 14 million, most people live somewhere in here. Okay. All right. So Virginia got rid of their state estate tax. Some states also clobber you, not just the federal government. Maryland still has it, the district has it, but Virginia got rid of it. So as long as we're under the Virginia, the federal, we don't have to worry about that in this state. But again, that's probate is 50,000. Federal estate tax is the other one.
I'm sorry, but earlier you said it depending on where you die. Do you mean where you die?
Where you reside, where your house, yeah. Not if you're taking a trip to another state.
Okay.
It's where's your home? Where did you pay taxes the year before? That's kind of like your state of domicile. is the term. Okay, so wills don't get you out of probate. You certainly don't need to be very wealthy to trigger a probate. What's so bad about it? Well, I have done this workshop all over the country, all over California, Arizona, Tennessee, Texas, all up and down the Atlantic, and I don't care what state I'm in, people don't like probate. There are three major things, there are many things, but three major things that people don't like about it. Here's the first one, it is lengthy. It is not a quick process, it is a lengthy process. It is also a very expensive process, and it's a very public process. Everything's open, everything's in the forum, documents are all made public. How long does it take an estate to get through probate? National average, 1 to 2 years. In the 20-some years I've been doing it in Virginia, 1 to 2 years common. Longest probate I ever heard was from a lady in Culpeper. Did a nice meeting there. After the meeting, she came up and said this. She said, Daniel, I'm not exactly sure how long my mom's probate lasted. She said, after 10 years, I told the family, I'm done with all of you. I'm not coming back. You can do what you want with my share. And then she leaned over and said, I think by then the lawyers were getting most of it. Could you imagine the legal fees of 10 years in court fighting with your family? Just before COVID, I was doing a meeting in Washington, D.C. After the meeting, a lady comes up and she said, they say it's going to be over soon, but we've been 5 years in court. Nothing's been distributed. Everything's still tied up in the probate process. Now, I want to make this really clear. 5 years and 10 years are not that common. They certainly happen, but what is common is 1 to 2. And that is still a long time that assets are frozen, money can't be divided, homes can't be sold. They're still tied up in the probate mess. The second problem with probate isn't the time, but it is the cost. There are the attorney's fees, court fees, filing fees, assessors, sometimes accountants get involved. And where does all that money come from? The estate, right? Assets that you were going to give your children or grandkids or your church are now going to attorneys, courts, judges. They say that if nobody fights or argues, everybody gets along. The national average of what is lost in probate is 8 to 10% of the gross market value. Now, I want you to hear, I didn't say 8 or 10% of your equity. I said gross market value. What would your house sell for, mortgage or paid off? That's the market value. Let me tell you this, Virginia is a little lower than the national average, yay, but it's still 6 to 8%. And don't forget, we're in the expensive part of Virginia, right? I don't have to remind you of that, Northern Virginia. Okay, so let me throw out some numbers. I'll be very conservative. You might have to remember your multiplication tables here. Let's say that your primary residence would sell for, on the market, $300,000. I know that was years ago, but we'll just say $300,000 was the value of the home. Everything else was another $100,000, investments and antiques. So your total estate in this example is just $400,000. 8% of that number is 32 grand. Folks, that's a lot of money your kids won't see. And that's, I'm sorry, that's if they don't fight. I'll tell you right now, if Susie hires a lawyer, because Jimmy hired a lawyer, and they go at it. Now, I've heard a zillion stories about probate over the years. I had this one guy tell me this. He said, Daniel, man, he said, I knew when we got to probate court, my sister was going to lie. He said, I just didn't think she was going to lie that much. She kept going on and on. Your Honor, this isn't fair. And Mom really wanted me to have that. And I know that's what the will says, Your Honor, but we were having a fight when she did the will. Story after story. He said, I finally had it up to here. He said, I blurted out in the courtroom. Mom would be spinning in her grave if she heard you. That's not true. He just called her out. The judge, hearing all this, said, would you all please approach the bench? So they all came forward. And the judge said, listen, here's my recommendation, is that you all go in the hallway and work something out. Because he said, right now you are giving your mom's money to these attorneys. And he said, if you haven't noticed, these attorneys are in no hurry to get out of here. The longer we spend arguing about where it should go, let me tell you, that is where it's going right now. So it can get adversarial. Now, when there is a fight, folks, I just want you to know, very often when there is a fight, it's not your children that started the fight. It's the ones they married. It's the daughter-in-law who says to your son, how come she's getting that? And the next thing you know, he's not talking to his sister, but the lawyers are, you know. It can get quite ugly. Think about the dynamic here, folks. It's money, and sometimes all of a sudden money, someone died unexpected. It's money, and then it's family. And then let's throw in the in-laws, and then it's expectation. I thought I was gonna get that. And then there's opportunity. And all of that is a perfect storm. I've heard hundreds of stories about probate. I will tell you, probably 70% of them start with a line like this. Daniel, I never thought my family would act like that. And then the story proceeds from that. You see a different side of people. So probate is not only lengthy, it is expensive. Here's the third problem. It's very public. Did you know that when you die with just a will, folks, your will becomes a public document and anybody can read your wishes? Nosy neighbors, ex-spouses, disgruntled family members, but not just read your will, anybody can also contest it. Now, listen, not all wills are contested, I know, but usually when they are, it's family. You know, why did Jimmy get in the boat? Why did Jimmy get in the boat? Grandpa promised me the boat. Well, at the end, Grandpa promised everybody the boat. You know, the wheels weren't spinning like they used to. Some of you in this room might remember, again, a young crowd, I'm not sure. Some of you might remember Charles Kuralt. He was a CBS reporter and he had a show years ago, On the Road with Charles Kuralt, Sunday mornings, soft news. Well, we discovered about 23 years ago after he died that he was not alone on the road, apparently. Here's what the article says. Woman lays claim to the Kuralt property. The article goes on to say that Charles died with just a will. As his will was going through probate, a woman showed up and said, Your Honor, Charles and I had a long-term affair. She called it relationship, but he was married, so you do the math. Your Honor, and I'm entitled to some of this. And she said, Your Honor, I can prove it. So out come the love letters and handwritten notes and receipts. We call that evidence. Today, it would be text messages and emails, right? You could ask Tiger Woods or Jenna Petraeus, I guess. So what did the court do? Well, they listened to her claims. They looked at the evidence she presented. And then the court, it says the court awarded her the ranch in Montana, all the buildings on it, and other property. And when I first read that, my first reaction was, why would the court do that? She's not even mentioned in his will. But remember what I said earlier, your will is a set of instructions, but it is not binding, and wills do get challenged, and in this case, successfully challenged. Folks, that's a lot of bad news. I do have good news this evening, is you don't need to have a probate. It's optional. When you get a revocable living trust, the first benefit is there is no probate waiting for your family. So instead of your assets being tied up in the court system for a year or more, literally within days of your passing, assets are available for distribution. Folks, I mean, while people are in town for the funeral, assets can start to be distributed. Now, I'm not going to shock you when I tell you this, but did you know that I happen to have a revocable living trust? So do my brothers, so do my sisters. Now, when I die, the family will all come to the funeral. Section 2 says they have to attend. Just kidding. My son will then grab the book and he will go to the bank. He will say to the bank this, hey, look, my dad's got 30,000 with you guys and my dad died last week. Here is his death certificate. And here is my father's trust. My father was the trustee. My mom is gone. I am Charles, the successor trustee. That's like an executor. The bank will say, well, you prove that your father's dead. Can you prove that you're Charles? And you'll say, yeah, present the ID. And the bank will turn to my son and say, so Charles, what would you like to do with this $30,000? Now think of what I just said. I died last week. Monday's the funeral. And Tuesday he says, 4 checks, please. Here are the names. And he closes the account. He calls his sisters over and says, here's the money from Dad's Truist account. I have 2 more accounts I'll be getting later this week. So come back next weekend. I got more. By the way, girls, while I have you here, who's going to help me get the house ready? I've got realtors coming on Monday to interview. There's no probate. There are no delays. We can start the process now. But what if I died without a trust and I died with just a will? Well, I'll go to the funeral. They come to the funeral. Next day, Charles goes to the bank. He says to the bank, look, my dad's got 30,000 with you guys. He died last week. And here's my dad's will. My father's will says I, Charles, am the executor. can I have the money, please? And you know what the bank says? I'm sorry, Charles, but this account is now frozen until the will goes through probate. Because folks, a will is not valid until the court validates the will. Now, let me tell you why. We're going to get to questions in a minute. If you could hold, if you need to write them down, just so I can sort of stay on track. A will has to go through the process. Think about this for a second, folks. Every will you've ever written, if you've ever written a will, says last will and testament. Nobody listening to me this evening wrote first will, second will, third will. No, they all say last will. How does the bank know if they're looking at the last of the last wills? There might be two more out there. So what they do is they freeze the account until the court says that's the last will. But with the trust, access right away. Instead of your family losing tens of thousands of your hard-earned dollars in the cost of going through probate, whatever you spend on a trust, folks, is going to be a lot less expensive. Now, I am not going to shock you when I tell you this, but did you know that attorneys don't do this for free? You can go out and find a nice attorney and sit in a leather chair and tell them what you want and have a trust made. I'll just tell you what people tell me. Daniel, we spent, and then I usually hear a number between $4,000 to $5,000. It used to be 3 to 4, now it's like 4 to 5. Of course, it's all going up. We do this for a lot less than that, but let's just say that what we charged was $4,000. Let's just say it was that. It's a lot less, but let's say it was 4. What is $4,000 compared to 8 or 10% of the 8% of the gross market value of your estate? We're talking tens of thousands versus a one-time expenditure of what it costs to make a trust. So this is a great value. This is a less expensive option than a will. Because a will might be cheaper now, but you have to pay a lot later. The trust you pay now and you're done. I do remind people, usually your estate's going to see one attorney or 2 attorneys. If you get a will, 1, and then you'll see him again. You won't. The family will see him later. With the trust, you get 1, you're done. The trust is. So this is not only is time reduced from a year or 2 to literally days, we can start distribution. Cost is reduced from whatever 6 to 8% of the gross market value to the cost of the trust. And the last benefit comparison is the privacy aspect. I mentioned your will becomes public and anybody can read your wishes. Nosy neighbors. After someone dies, something shows up in the paper like 8 or 10 days later. What's that called? Obituary, right? Sometimes called a death notice. So-and-so died, survived by, he loved working or whatever it was. A year or 2 later, something else shows up in the paper. You know what that is? It's the notice for probate. Every court appearance has to have a notice telling people to get ready. I brought a few examples up here, and these are, this is going to be your local paper, not the Post. It's where you find the yard sales and the flooring company guys, And in the very back of these little papers are these legal sections where the print gets really small. You've seen this, right? In every one, there's a headline, and it's 3 lines, and they're in bold print, in capital letters. And the headline is this: notice to any creditors, notice to any unknown heirs, notice to all persons interested in the estate of, and then there's the name of the deceased. So who was just invited to probate? If you can Google, you can get interested. And then it tells you the name, when they died, and if they had a will or not. Now, these are a little more current. This is just an oldie one. This was during COVID. This is 2020. This person died in September 2017 with a will, 2017 with a will, 2019 with a will, and on, 2018 with a will. But this person died in 1998 without a will. 22 years later, they're still in probate. Now, the point of showing you this, and these, they go back to 2011, and this is 2021, so there's 10-year-old mothers, isn't so much that it took a year or 2. No one's going to tell you probate's quick. It takes a long time. But everyone except one says with a will, with a will, with a will, died with a will. There's still a probate. So if you leave here and your neighbor says, oh, I'm fine, I got a will, there's still a probate waiting for their family. They just haven't read the paper. The paper will tell you that. So that's a lot of publicity. Not only does your will become a public document and anybody can read what you left, anybody can show up and find out who's getting how much, where it's going. Let's contrast that with the trust. The second benefit I put is privacy. Folks, the only one that gets to see the details inside your living trust when you die are your named beneficiaries, and that's it. Not nieces, not nephews, not neighbors, not ex-spouses. Only the people whose names you've written will have a chance to see the details. And that's one of the many reasons why Susie Orman, Wall Street Journal, Forbes magazine, they're all telling you, you want a living trust. Modern Maturity magazine wrote this a while back. Out of here somewhere. They said this. Somewhere, I got it memorized. I could probably just say it. They said, here it is. If you look forward to going to the dentist or paying taxes, you might like probate. Probate is costly, slow, outmoded, a sad state of affairs, but then they write, trusts, however, are a valuable estate planning tool. Anybody here familiar with Susie Orman? Maybe you've seen her on TV. A lot of you have. Here's what she said. Susie said, regardless of how much you do or do not have, in most cases, a will is not enough. She said, you will also need a revocable living trust with an incapacity clause. What's that? The powers of attorney, the advance directives. That's what Susie wrote in 2004, which was 21 years ago. Here's a more current article from Susie. She writes, in trusts we trust. I love the play on words, I have to admit. Let me read you one line from this article. She writes, wills are required to be approved by a probate judge. But with a revocable living trust, your estate is dispersed exactly as you laid out in the legal document. And then she writes, no need for your heirs to get court approval. We're bypassing the court with the trust. We talked about the do nothing plan. I certainly do not recommend that. A will is certainly better than nothing. I will acknowledge that. Better to have something in writing than nothing, but there still will be probate. It still could be contested. By far, the trust is our best option, but I do want to bring up one more option, and I don't recommend it, but I want to talk about the dangers of joint tenancy. I don't know if that's the video you sent, but let's talk about that. Most couples own assets together, right? Jointly. And when one dies, who owns it? The other one. And there is no probate when the first spouse dies. But eventually the second spouse dies, and then there's probate. What happens if the couple that owns the asset together dies together? Car accident, COVID, something, instant probate. There's no one left on the title for it to fall to. So just so we understand the basic rules here, joint tenancy doesn't solve your probate problem, it just postpones it until the second one goes. Are you following me so far? Some people think they've come up with an idea, and here's what they say. Well, now that my spouse is gone and I own the asset, whether the house or the accounts by myself, I don't want it to go to probate when I die. I've got an idea. I'm going to put my son or daughter on title with me. That way, when I die, they'll take over. Skips probate. Well, folks, it does skip probate, but it opens up so many other problems. In many cases, it's worse than probate. Probate's bad, but there are things worse than probate. Here are 3 reasons you do not want to own assets with your children as a way to pass the estate to them. Reason number 1 is a bad idea, liability. When you put your son or daughter on title of your home or bank account, they're not just joint tenants, but they are now co-owners. They are co-owners. As a co-owner, if they get into a car accident, their dog bites somebody, someone slips on their property, there's a lawsuit, there's a judgment, what could they attach? Anything they own, and they now own half of mom's estate or dad's estate. Imagine this, you put your daughter on title a few years ago. She now discovers her husband, your son-in-law, is cheating on her. She throws the bum out, they divorce, but in the divorce settlement, half of what she owns goes to the ex. Shall I translate? 25% of your equity just left with your ex-son-in-law. Why? Because you gave her half and her half got settled in the divorce. Folks, my simple point is when you commingle assets with your children, their problems become your problems because they affect your estate. That's just reason number 1. I have 2 more. Reason number 2, it's a bad idea, distribution. Let's say that the 4 of you are my 4 kids and I make a deal with my son. Look, mom's gone. I don't want the house to go to probate. Why don't you and I own it together? Now, son, when I die, I would like you to sell the house and share it with your sisters and your brother. And he says, okay, Dad, I'll do it. The question is, does he have to? No, he got a house and the three of you got disappointed. I'm gonna tell you right now, I hate to break the news to you, but brothers cheat sisters and sisters cheat brothers, and they somehow justify it. I guess Dad knew I needed the house. No, you didn't do what you said you'd do. But let me make this really clear point. I had a plan. It was just a lousy one. Deceased father cannot make him sell, and neither can his siblings. I lost control of distribution. I had a guy come to my meeting. He was 75 years old, still steam coming out of his ears because mom thought it would be easier to put the daughter, his sister, on title and then she would share. He was still mad. It'd been years. He got zipped. She got the whole property. Mom, so she had a plan. It was just not what she thought it was going to be. Happens sadly all the time. The third reason, there's a third reason, whether you have multiple heirs or one. Let's just say you have one heir, it's a daughter, her name is Barbara, and you put Barbara on the house with you, and then you die. Now Barbara owns the house. But watch this, when Barbara goes to sell the house, she has to pay capital gains tax all the way back to your original purchase price. So imagine you bought your current house 20 years ago and paid this, and 20 years later, it's worth this. That's called a capital gain. Let's just make the math easy for the speaker. 2 decades, let's just say 200,000. I know that was the last few years, but 200,000. You know what 20% of 200,000 is? $40,000 to the IRS in capital gains tax. But listen to this. None of that's going to happen when you pass it through a trust. When you pass your estate through a living trust, your children are not co-owners. They are beneficiaries of the trust. And as beneficiaries of the trust, there is zero capital gains tax due, none, zero, because everything in the trust when you die goes to your heirs at the current value. It's called, if you want to know the CPA term, it's called a stepped up tax basis. The IRS doesn't care what you paid. What is the value when you died? That's the value it shifts to your family. But folks, not just your house. What if you're blessed enough to have a second home, a vacation home, or a rental property? That also gets a step up tax basis. What about stock you bought 30 years ago for $20 a share, now trading at 120 through the trust? It goes at the current value. No capital gains at all. No capital gains tax at all. There's no distribution problems with my trust because if my trust says 25% for my 4 children and I die, what's the trust say? 25%. It's not negotiable. It's not contestable. Look at the words here for a second, folks. Revocable living trust means while I'm living, I can do what? Revoke it, change it. But when I am no longer living, the trust becomes irrevocable. And do you know what irrevocable means? Cannot be changed. So I often tell people, if you don't like what your parents wrote in the trust, when they die, you will have the right to be disappointed. And that's it. You can't change it. Upon their death, the instructions are binding. It may as well be called revocable while living trust. In other words, that would be a descriptive name. While we're alive, we can adjust it. Now, some people adjust it because there's a falling out. You know, so-and-so said, see you, mom, dad, I'm never coming back. You might change it. Sometimes it's you give them some money in advance. And to be fair to the others, you might make an adjustment. But people do change their wishes. The trust is revocable, but upon your death, it is irrevocable, which means cannot be changed. Frankly, I would rather my kids be disappointed with me than angry at the sibling that got away with something in court. So the truth is, I get to decide what's fair. And that's the way it gets to be. We are in control. And the last thing is the liability. Just because I have a trust today does not mean my daughter cannot divorce her husband. Sure, she could. It doesn't mean my son couldn't drive too fast with the car and injure somebody. That could happen too. But if those things happen today, folks, those things will affect their estate, but not my estate, because we did not commingle the assets together. Are you following me? So there might be another way to avoid probate, but it comes with so many downsides. With the trust, I'm saying, hey kids, here it is, come get it. No fighting, no courts, no delays, no taxes, significantly better in a zillion ways. What I would like to do now is pass out a little company brochure, tell you a little bit about who we are, and we'll just do a little commercial here. I'll get everybody, I'll get y'all.
Thank you.
Sure. Awesome. All right. I do promise we are going to stop for questions at least twice a little later on. Turn to the inside here. You're going to see my picture there. And this is sort of the About Us section. Started the company some 20 years ago trying to help people learn about this important subject. My wife's a retired teacher. We believe in education. A lot of people, after they've heard me, realized that the education part was good, but I also need to do this. So if you do want to work with us, you're going to work with one of our attorneys. And the two top attorneys above the line are the Virginia lawyers. There's Mr. Dezio and Mr. Domazic. You can read about their background and where they went to school. We've even listed their state bar license number there so that you can independently check them out. As you folks probably already know, in this world, there are attorneys, and then there are some good ones. We only want to work with the good ones. Now, President of the American Bar Association made an interesting comment years ago. He said this. He said, any attorney can write you a will. They all learned that in law school. He said, your local real estate attorney could write you a will. But he said less than 1% of attorneys have ever made a trust. And then he added, let alone a good one. So you want a good trust attorney, someone that does this for a living. A simple analogy is this. If I ever need heart surgery in the future, I want you to know I'm not going to go to the ear, nose, and throat doctor because he's closer. I will find a heart surgeon. Well, geez, Daniel, they all went to medical school. I know, but I want the one that works on the heart. All lawyers go to law school, but you want a lawyer that does this. So we've given our clients some expert attorneys there. Okay, the next page are just notes that you don't have to take. I already took them. And it starts with common estate planning strategies. There's the do nothing plan, which eventually becomes the state plan. The government will make your choices if you don't make them. Then it talks about a last will and testament plan, which still, of course, means probate delays and costs. And then there's the revocable living trust plan. Below that, going down that column, it says other important estate planning documents, and we talk in more detail about the powers of attorney and the advanced directives. On the top right, it says dangers of joint tenancy, and we just discussed why you don't want to own assets with your children as a way to pass the estate to them. Go down to a little further, it says the perils of probate, and the first line after what is probate, let me read that. It says probate is the court supervised process that oversees the distribution of assets owned by a person when they die. Go down to the blue banner, minimum market value to trigger probate. And we just gave you some examples, alphabetical, Virginia, there it is, 50,000. That's all it takes to trigger a probate. Below that, what are the key probate problems? We've already discussed. It's expensive, takes quite a bit of time, no privacy, no control. Folks, a lot of what I'm going to tell you this evening is already in print, so you don't have to do the notes, did that for you. On the very back, if you will turn, our testimonials. People have written in about our commitment to service, the quality of the documents, the value that we provide. I would encourage you, if you're at all interested, Google our name, read our Google reviews. We're also A+ rated with the BBB. But I want you to check us out. Feel free to do that. The last section next to this lounging, relaxed couple, it says, why choose us, and some of the things that set us apart. Let me talk to you about the process. You cannot come to a workshop and go home with a trust. A trust needs to be made, right? There's the interaction with the attorney. Before I dive into that, I want you to know that I'm an invited speaker at different churches. I speak at Cornerstone Chapel once a year, Reston Bible, different churches across the country. But I was doing a meeting at Reston about 10 years ago, and this lady said this, Daniel, I'm not too familiar with this subject, but based on all of this, she goes, why is anybody still going with the will? And she said, why would you spend $800 or $900 on a piece of paper that sends everybody to court? And it's not even binding, meaning what I've written could be changed. I said, well, all of that is true. But what I think the reason is that a lot of people have heard of a will, but they don't know what a trust does. They weren't told the will is going to go to court. The will is not technically binding. It can be altered and changed by that was never explained. And so maybe the only thing you knew about a trust was that's what rich people have, right? Or it costs about quite a bit more. So I think I'll go with the will, But there's another reason people end up with a will, and this actually makes me mad. They were talked into it by the attorney, who happens to have a trust for his family, but doesn't mind writing wills for you guys. I wonder why that is. Sometimes they're not thinking of you, but they're thinking of themselves. Now, I've got an article written here by Wall Street Journal, and it talks about the will pushing lawyers. And Wall Street Journal wrote this: revocable living trusts become popular option in estate planning. And then it tells you why they're popular. No fighting, no courts, no delays, no taxes. But then down here in the article, it says this: but be aware, many attorneys do not go out of their way to bring up a trust when a client comes in for a will. It says these attorneys would rather take your $800 or $900, write you a will, and then it says, then meet the rest of the family in probate, where they make half of the probate fees. I didn't write this article. I'm just telling you, Wall Street Journal is telling you they're not always thinking of you. So I've talked to people over the years, you've got a will, how did you get that? Well, we found a lawyer, we told him what we wanted. The will was typed up. We looked it over and said, yep, that's it. That's what we said. So we signed it. The notary stepped in and notarized it. And then they made a copy of the will and they handed us a copy. Now, the original of your will goes into a file cabinet in his office with all the other wills. And when you're not around, he calls that his retirement account. No, just kidding. Now, here's what happens. Every morning, someone comes into the law firm. They start the coffee. They open the newspaper. And what section do you think they turn to first? Obituaries. It's called the client search. Have you ever done a word search? They're looking for names in that drawer. So it's Anderson, Garcia, Johnson. Oh, we got a Johnson. Oh, that is Mr. Johnson. I thought he looked familiar. Out comes his will. Looks like his son David's the executor. We'll give him a call this afternoon. Ring, ring. Hi, David. Gosh darn it. Sorry to hear about your dad's passing. Read that in the paper. Hey, David, as soon as possible, we're going to need you to come to the office and sign some papers so that you can get your inheritance. That is the beginning of the probate process. Let's say at this stage, you'd rather get a trust. How do you get one? Let me give you 3 options. You can find a lawyer on your own, Yellow Pages, Google search. Does anybody use the Yellow Pages anymore? Old school, But find a lawyer who does this, sit down, pay them what they charge, and get a trust made. You will not only spend at least $1,000 more than we charge. That is just the beginning. If you haven't worked with lawyers very much, congratulations, that's usually good. But if you haven't worked with lawyers very much, you may not know this. Most attorneys are very transactional. Do you know what I mean by that? Every phone call, every email, every anything, there's a bill associated. It's called billable hours. If they say, please respond that you got this email, and you say, got it, that was 35 in, 35 out, $70 just went like that. I've talked to many people over the years that say, Daniel, I spent $3,500 on the trust, but every time I call the lawyer, it's another $200. So then they say, guess what I don't do anymore? I don't call the lawyer. And I go, well, that's sad. You spent a lot of money with that law firm, but you don't feel the liberty to pick up the phone because you don't know what it's going to cost you. That is not who we are. As a company, we give our clients a lifetime of ongoing consultation. We say, if you have a question, please pick up the phone and call us and talk to us. There is no bill in the mail. Because that is our policy, we get phone calls and we're happy to hear from our clients. Some of the calls sound like this. Hey, Daniel, you may not remember us, but we got a trust from you guys about 9 years ago. We're thinking about moving to Colorado to be closer to the grandkids. Does the trust we made here in Virginia work in Colorado? And we say, yes, once the trust was signed and notarized, it's good in all 50 states. You don't need to make a new one because you cross state line. However, the powers of attorney are state specific. So make sure, go to the bank with, in Colorado, show them what you have, or we can make you new ones for that state. There's a question, there's an answer, it didn't cost them anything. Another call. Hey, Daniel, my mom passed away. I'm inheriting a piece of property from South Carolina. How do I put the South Carolina property into my Virginia trust? And we say, just tell the title company you want to take ownership as trustee of the Barbara Johnson Trust. And she says, that's all I need to say? And we go, that's all you need to say. But my point is, if you don't know, you don't know. I'm just telling you, most of you are not going to change the instructions a lot. Okay, kids, you're out. Okay, you're back in. No, but the instructions will stay, but assets will change. sell a property, buy another property, change banks, change brokers. How do you do that? Pick up the phone, we'll talk to you. There's no bill in the mail. Well, let's go from the expensive law firm that charges you every time you pick up the phone. Let's go to the other extreme where you don't use a lawyer at all. And you run down to Staples and buy a kit, fill in the blank. Or you go to LegalZoom.com or WillAndTrust.com and create your own documents on the internet. The problem with the kits, whether they're online or they're paper, is there is no attorney guiding you, helping you, answering questions, double checking your work. No. It's you with your law degree creating a complex legal document that you hope works. And if it doesn't, just a reminder, you won't be around to see how it turned out because you're gone at that point. Now, I do not have to say anything bad about LegalZoom, so I won't. But I will read you what LegalZoom says about themselves. These are their words from their website. Go to any search engine, type in LegalZoom disclaimer, and here's what pops up. I'll give you 4 quick points. LegalZoom is a document service and not a substitute for the advice of an attorney. LegalZoom is not permitted to engage in the practice of law. Therefore, you will get no advice, explanation, opinion, or recommendation. So if you're doing it wrong, they can't stop you. Here it says LegalZoom will not review your answers to see that they're legally sufficient. But I love this one. LegalZoom cannot guarantee that the information on our website is current. If you're comfortable with that, you may save a few $100. But again, you'll be wondering if this is right. And here's the simple point. If you made it wrong, who made it wrong? You did. They didn't. They just gave you a template. We think that's a little dangerous to do. So we're not the expensive law firm, but we're also not the kit. We're a company that uses great lawyers to make great documents. And the way that we do that is we break the process into 3 parts. The first part is always education. Come learn. How does this work? Why would I want one? What do you charge? I'm going to tell you all of that stuff. But I will give anybody an opportunity in the room if they want to get started. I have applications. I can pass them out. And people do sign up. And for those that do, you're done with phase 1, education. We move on to phase 2, consultation, where you're going to talk to one of those lawyers. You are not going to talk to a paralegal. You're not going to talk to a secretary, but you and the attorney will discuss who's getting, who's not getting. The details of what you want to accomplish will be discussed with the lawyer. When you're done talking with the lawyer, the trust is created. And then the third phase is it needs to be executed. So we create a scenario where you come to the office and sign and notarize. The office that anybody here would be going is it's in Manassas, Balls Ford Road, about 7-8 miles away, not very far. So there's the 3 parts. You learn about it, decide, yeah, I want to do it, interact with the lawyer, questions answered, questions brought up, and then the last part is sign it. Let me talk about the interaction, and this is universal whether you work with us or anybody else, but the interaction with the lawyer is really important. We think in order for us to be as efficient as possible, we think that you, the client, should know what the attorney is going to ask before they ask. So instead of sitting in a lawyer's office with the meter running and you're getting hit with questions, we give you the questions in advance. So it might sound like this. You're sitting at home with the questions and you turn to your spouse. Honey, listen, it says the successor trustee, like an executor, is the person or persons, could be 2 working together, that will carry out our wishes when we're gone, sell the assets, divide the estate. I know, honey, we were thinking about maybe John doing that, but now that I see it can be persons, maybe John and Kathy could work together as co-successors. But by hearing the questions, you're now starting to think about your family and your situation. You might even call them and say, would you guys mind working together? But you had the questions in advance. This streamlines the process, giving you ideas before you even know. So I'm going to pretend for a second that I'm the lawyer. I am not the lawyer. We have lawyers, but let me just go kind of play through a conversation with a client. So after the hellos and how are yous, the attorney says, let me ask you some basic questions. Tell me, when you die, do you want everything to go to your children? Do you want it to go equally? Do you want to give some assets directly to grandchildren, sort of a grandparent gift? What about churches or charities or organizations? Do you want everything to go from the trust to your heirs as soon as you die? Or would you like to leave some assets inside the trust for years after your death to fund your grandkids' education, or maybe great-grandkids' college education? See, what a lot of people don't know, and is they just don't know, but you can leave assets inside your trust if you want. up to 70 years after you've passed away. I do not remember my great-grandfather, but if he left me money for college, I would remember him fondly. We have a dear friend of our family, graduated from medical school about 10 years ago. He's now a doctor. He's in his mid-30s. He graduated medical school with zero debt, one of the few in his class. How did he do that? His grandfather created a trust, and his grandfather's trust said something like this. Hey, grandkids, listen up. There's money over here, but there is no money for trips and motorcycles. It is for your education. And he said to his grandkids, go to the best school you can get into. I am your scholarship. He said, I haven't talked to my grandfather in 15 years since he passed. He said, but I thought about him every time my tuition got paid. You know why? Grandpa thought about me 30 years ago. All I'm saying is with the trust, you can think multi-generational blessings, not just on your kids. Now, a good attorney cannot just make a plan, but a good attorney must help you develop a backup plan. We have to think about things that we don't want to think about, but we must. So the attorney is going to talk about what I call contingencies, the what ifs. So the attorney might say something like this. I see you have a son and a daughter and you want them each to get 50%. No problem. But what would you want to have happen in the event you died with your son? You go out to dinner, car accident. Would you want his share to go to his sister? Or would you want his share to go to his wife? Or would you want his share to be kept in the trust for his children, your grandchildren? And another question, when would you want it to go from the trust to your grandkids? When they turn 18? Well, you can do that, but they won't have any money at 19, right? How about 25 or 30? Someone the other day said, keep going. But the truth is, if you say where, I guess it would go to his kids, but you don't say when. You know when is? 18. You know what an 18-year-old does with an inheritance? College? Who needs that? 2 years later, the money's gone, and so's the scholarship. All because someone didn't ask a simple 4-letter word, when. We happen to think 25 is a lot better than 18. I have many clients who say, if it does happen, let's make half at 25, half at 30, and let them make their mistakes on half of it. My point is, the questions, look, we don't know what we don't know. You have to be asked and then responded to. Now, let's say I do one of those kits, fill in the blank, and there's a section that says, special instructions, and then some empty lines, and I go, honey, I know I heard about this at a workshop. What about leaving some money for the grandkids' education? I don't know, 30,000, no, 60,000. That'll get them started at least. Okay, 60,000 will be set aside for the grandkids' education. I die and my grandson discovers there's money in a trust for his education. You know what he says? Woohoo! I'm going to jet ski school in Florida this summer. Well, that's not what I meant. But it says education, and he wants to learn how to ride a jet ski. It's called C-Do-U or something. A good attorney would say, Daniel, when you say the word education, did you mean an accredited college, a university, a trade school, a law school, a medical school? And you know what I'd say? Yeah. And he would say, well, we better write that, because if we just say the word education, it could be Joe's fishing school. Precision language gets precision results. Now, again, we have to talk about uncomfortable subjects sometimes. That's just the reality of talking about the future, what could. We don't want to make a trust just for the best scenarios, but all scenarios. Well, let's face it, within families, there are people we love and there are people we tolerate. Some people tell the attorney this, hey, look, I want this to be written such that, understand, I do not like my son-in-law, don't like the way he treats my daughter. This money's for her, it is not for him. If I die and she's not there, I want her share to go to her children, but not her spouse. And the attorney will say, not a problem, we can exclude the son-in-law or the daughter-in-law. But a good attorney says, I got one more question. When you say you want it to go to your daughter, but if she's not there, it's to go to her children. When you say her children, did you mean biological children? Because what if later in life she remarries someone who has 3 kids from a previous marriage? She didn't raise those kids, but those are her children. They're called stepchildren. Stepchildren are children. Foster children are children, but those are not biological. Are you following me? We have to define the terms. I had one lady said, I've never met my son's second wife's kids. Why would I consider them grandkids like the ones that come every Christmas? And I said, apparently you don't. We better make sure this goes to the right grandkids, but we have to define those terms. So this is where, again, these are the things you don't know unless somebody asks you. You're not thinking of the death of your kids. It's not natural to think of the death of your kids. If I had anything to say about it, parents die first. But sometimes it doesn't happen that way. We have to plan for different outcomes, and a well-written trust does plan for all of that. Now, when my trust was written 20 plus years ago, all of my kids were under the age of 18. So I have a section called guardianship. Who's going to raise those kids if we die while they're minors? Well, my youngest is 28, had a baby today. My 10th grandchild. My oldest is 39. So they're all out of the house. They're married. They're I don't need guardianship for them anymore. It was important for many years. At this point, it's an irrelevant section of the trust. My sister, who's older than me, has a trust, and she has a daughter, my niece, that's going to turn 50 this year and still needs a guardian because she's got special needs, God bless her. She's been getting what we call SSI checks, from the government because of her disability over the last so many decades. If I were to give an inheritance to her, hey, Deborah, here's some money from your Uncle Dan. You know what the state does? They take it. The state says, thank you, Deborah, that's reimbursement for all the years you've been on government assistance, and she never sees her inheritance. Or the state says, Deborah, now that you have this money from your uncle, you don't qualify for SSI because it's needs-based, and so the checks that she's been accustomed to getting would stop. Now, let me say, neither of those is a great result for my disabled niece. What we will do for you without charging any extra, if you have a special needs family member, we will create a special needs provision. This is like a trust inside the trust. When I die, the other assets go to the other heirs right away. Homes are sold, money's divided to the other heirs. But the money that I left for my disabled niece will stay there. And every month after I'm gone, she gets a little until it's gone. But listen, that money over the next few years, folks, will supplement her checks. It will not jeopardize them. Isn't that better than losing the money? But how would you know unless someone said, we can't do that, but we can do it like this? This is why we have lawyers in the process. Okay, phase 3, you've talked to the lawyer. The trust needs to be signed and notarized. We'll make an appointment, sit down, sign and notarize the document. Once the trust is signed and notarized, we'll say, congratulations, you're now a trustee. But we have to put something in the trust. So the day that my wife and I signed our trust, we also signed a transfer letter telling the county to change the deed. The deed of our home went from Daniel and Christy Leonhardt, the owners, to Daniel and Christy Leonhardt, the trustees. It's still our name, it's still our house, but I'm not an owner now, I'm a trustee. The difference is this: if you remain an owner, it triggers probate when you die. If you remember what I read is the distribution of assets owned by a person when they die. Well, if the trust owns it, I don't own it, no probate. But though the trust owns my house, who still lives in the house? The trustees. Who pays the taxes? The trustees. Who pays the mortgage if there is? Trustees. There's no difference. I still write checks now and then. I slide my card at Subway and they give me a sandwich. Where'd the money come from? The trust. So we put the assets in the trust, but then we enjoy them. So the secret to this whole thing is don't be an owner anymore. Be a trustee. Have assets, have homes, have millions, but don't own it. Let the trust own it. Just a real quick, so you know this, trusts aren't new. The first trust was written in America by Patrick Henry, and it was written in 1765 for Lord Fauquier County. Yeah, trusts have been written before the Constitution was signed. So these things are there's just different ways to have assets. You can be an owner or you can be a trustee. Families don't go to probate. That's the secret. So we have to do the transfer of assets to the trust. We'll get into more details a little bit later on. A couple more things before we get to questions. Sorry, it's been a long stretch, but we're going to get there. These are important parts of the trust. All of it's important, but the powers of attorney are really important. I did a meeting in Manassas about 10 years ago. After the meeting, this gentleman comes up and says, this is great. I love what you offer. It's a great price. He said, I'm not sure you can help us. He says, my wife has Alzheimer's. She would not have understood anything you said today. Can you make a trust for us? I said, I can under one condition, and that is that you already have the power of attorney from her to you, meaning that was established before she lost, mental capacity. He said, interesting. 5 years ago, I started seeing the signs. She doesn't notice, but I noticed she's forgetting names of friends and she forgot we ever lived in Pennsylvania. So on a really clear day, we went to a lawyer and we got a power of attorney. I said, then we can go forward. She's already consented to let you manage. And so we made a trust for them. He's the trustee, not her, but a trust for all of their assets. I was doing a meeting a little later in Maryland, and this lady comes up and she goes, Daniel, my husband has dementia. It's horrible. It's really rough. We have no documents, no wills, no powers of attorney, nothing. I said, I'm sorry to tell you, ma'am, but you're going to have to go to court and apply to be your spouse's conservator. In Maryland, it's called a guardian, but it's the same role. I have to ask the government's permission to act for my spouse. You know what court she has to go to? Probate court. It's called a living probate. This process costs between $6,000 and $8,000. I've heard up to 10, but that isn't even the worst part. As much as you wouldn't want to spend 6,000 or 8,000 to do what you would have done anyways. The worst part is every month you have to itemize every expenditure and send it to the court for supervision. Yep, we went to Dairy Queen. We got a Blizzard. It was $6. Could you imagine having to itemize everything because the court gave you permission and they get oversight, not your spouse giving you. Are you following me why these are important to keep that from ever happening? Okay, I want you to know this is not my personal trust. Mine's at home. Of course, it looks like this. This is what our clients' trust look like. But imagine this, I have a terrible heart attack. I'm taken to an emergency room unconscious. My children show up and say, how's dad doing? Doctor says, well, he's stable, but he's unconscious. We need to do surgery. Which of the two of you children has the power of attorney for healthcare? I need someone to sign off on the surgery. My daughter says, I think that's me. You know what the doctor says? I think that doesn't count. I need to see the documents. So the children have to leave the hospital and go to my house and try to find them. Geez, where does dad keep this stuff? It's as messy as when I lived here. Oh, great, there's a safe. Do you know the combination to dad's safe? I don't. I play that out to imagine you took the time and the energy and the expense to create this, but when you need this, there's a glitch. That'll never happen to me or you, because if you work with us, you will get a card made up for you. If you're married, you each get one. And it says emergency access to my medical directives. This card, even though you're unconscious, will tell the doctors your name, the name of your primary healthcare power of attorney and alternate and phone numbers to reach them. This will also tell them that you're allergic to penicillin or sulfa medication, that you have a medical condition like diabetes or asthma. It will tell them the name of your primary physician and phone number. And it will also give them the HIPAA, release. You know what that is? So they can speak freely to family. But not only that, before they roll me into the OR, the nurses at the nurses station will go to this website, punch in my member code, and right on the computer at the nurses station, they will see my powers of attorney and my advanced directives signed and notarized and print them right there at the station. Folks, you will not get this when you just go to a lawyer, but you'll get this when you work with a company that just does estate planning. We discovered after many years of making great documents that no one was taking the trust with them on vacation. But you don't need to. Just take the card. Couple more things. The day that you sign the trust, we give you a year to change it. All you have to do in the first 12 months is pick up the phone and say, I don't like what I wrote. And we'll say, what would you like it to say? But changing and amending the document is free of charge for 12 months. During this 12 months, we're going to enroll you in our nationwide legal network, and we're going to give you access to more than 15,000 lawyers, not just those two, but you will have access to real estate attorneys, tax attorneys, elder law, injury, criminal. These attorneys will not only talk to you, they will write letters on your behalf, make phone calls, review legal documents, and all of these services are free when you get a trust with us. But they are not free forever. They are free for 1 year, 12 months. In the 11th month of your year, we will send you a notice. It's an email, and it says this. Hey, we're coming up to the 1 year anniversary of when you signed your trust. You have 30 more days of free legal services. If you want to change the trust or talk to a lawyer about any legal situation, please call us now while it's free. But the email will go on and say, however, if you would like to extend these benefits into a second year, you can, but we do charge. The first year was no charge. It comes with the trust. Anybody that wants a second year or to keep it going, it's $125 a year. That's about $11 a month. Most people say leave it on the card, but not everybody. And you're not required to. You have the option to renew it. Even if you choose not to, you still have a great trust made by a great lawyer, good in all 50 states, still no probate, and you still get a lifetime of phone calls because calling us is always free. Now, when you die, you cannot call us anymore. That is a rule we have. But your children might want to know, what am I supposed to do with this blue binder? Well, most children, all they know about their parents' trust is, I think it's called a trust. So we built a section for your heirs, and it says settling the trust estate. And back here, it's going to tell them things they're going to need to know, like how many death certificates do I get? Where do I get them? And we're going to tell them you should get at least 10 or 12 because everybody wants one and you can't make copies. Oh, the deceased was in the military. It says the VA will pay for some of the funeral expense. Also provide a headstone marker and an American flag if requested. How do I access my parents' safe deposit box? What do I have to show the bank to get the money out? Not only that, there are checklists here. Did you cancel your parents' credit cards? Have you contacted Social Security? There's things they're going to need to do. We've got them here listed. Your children can also call us, phone numbers right here. So they will have printed instructions and verbal instructions, no bill in the mail. The benefit to your family is obvious. You know what the benefit to us is? When your children want to trust someday, who do they know? The people that help them with mom and dad's trust. We get a lot of repeat business, not from you, but from others, from your kids. Let's take some questions.
He is going to get into what goes into the trust, what doesn't, what about accounts with beneficiaries, pay on death accounts. But questions other than that, what questions do you have? And yes,
I was just wondering, is it really true that the trust can't be contested even for things like the lack of capacity or undue influence?
correct. And the reason is it's signed and notarized, and the notary's role in that is to verify this person's of sound mind. They are who they say they are. So when it's been signed and notarized, it's binding at that point.
How is that different?
So good question. Wills, and the way that they set up the law is the will is looked at as a letter to the court. A trust is looked at as a binding contract with your beneficiaries. And trusts have been written in the US since before the Constitution. Patrick Henry, Benjamin. Okay, well, so they go back for a long time, but just like if I had an LLC and I can have different advantages within an LLC than I do as a personal, as just a person on it. So the laws allow for it to work the way, because it's a binding contract with the heirs. Yeah. Yep. I'm his son, Charles. I've been working for him for 30 years, 34.
Introduce yourself.
Yeah, no, not a problem.
So you're talking.
Yeah, absolutely. Yeah, good question. Any others? I thought I had another hand. Yes. Yeah. Yeah, so yeah, with the transfer on death deeds, what I'll say is those are limiting documents, because if you move, you have to redo it. And if the person you're going to transfer it to has passed away, it goes through probate. So it may be an option, but it's a limited option. There's also been issues when it comes to the person that you're transferring it to. What happens if they're impaired themselves? Well, they now become owner of a home. And if they were getting government assistance, they are now disqualified, or the home could be, there could be a lien against the home based on certain circumstances. So yeah, so we would revoke the transfer of death, and then we would essentially assign it within, it's two different forms. One would be the revocation of the transfer on death deed, and then the other would be the deed putting the property into the trust. But we can do that for you. We had folks, they had, I think it was 5 properties down in Norfolk, and we did that for all 5, just to help them do that. Yep, but we can assist in that. So the question is, just so they can hear, is if somebody only has one child, is a trust necessary? I'd say yes. The reason being is if it's one child and everything's supposed to go to them, they still, and you don't have a trust, they still will go through probate by themselves without anyone else. And the attorneys will get involved. Now, the question is, will there be a lot of infighting? There might not be, but I'll tell you, we had 2 sisters that were, their mother had a simple will, everything went to them. They were the executors, they were the only beneficiaries, as straightforward as it can be. They didn't argue once. They said it took them 18 months and cost $18,000. And they said it was because the attorneys were incentivized for it to take longer. They still have to go through the court system.
Yes, it states, approximately how long it will take if there is no problem, no fine.
I can't, because I'll tell you, I've hear stories all the time of, I was a single child and it still took us 2 years because I had cousins that came and they were talking about this or that. So again, it's one of those where there's a possibility that it could be somewhat smooth, right? I could run across 66 a bunch of times and there's not a good chance that I'm not going to get hit every time. So it's one of those where you kind of take the risk of, okay, am I hoping that it's going to be okay? Or do I go with the guarantee knowing that no matter what happens, they're going to avoid the courts, they're going to avoid the headaches, and it goes to them right away. Any other questions?
I have one.
Yeah.
So you don't pay any capital gains on the trust, but what if they, like, if you own homes and then you, in the trust, you leave it to your children, they sell these homes.
Yeah.
Do they pay capital gains when they sell it?
So if they receive through the trust, it gets a stepped up tax basis. So they're receiving the home at the current value. If they sell it right away, there's no capital gains tax. But if they keep the home in the trust, let's say for another 2 years, and there was $50,000 of growth in that, they would pay capital gains tax on the growth from the time that you passed.
Okay.
That would be when capital gains tax would come in, but most of them are going to sell it or they'll keep it. There's already a good bit of stepped up basis there. Any other questions? Yes.
Is there any benefit to doing like early distribution of trustees? So when you've got a trust in place already, and say both your parents have to go into assisted living, is there any benefit to doing distributions before that happens? Or anything like that?
So, because everything that's in the trust is fully yours. So if you wanted to start giving it away soon, right, while you're living and see them enjoy it, you absolutely can do that. The question would be if it's kind of more for like the Medicaid side of things, planning for that long-term care, there's always going to be the 5-year look back period. So if you start to see the signs a little bit early and you start to give it away, they can still, and if it happens within 5 years, they could say, hey, you hit some in the mattress, right, where that's still going to count towards that. Yep, I think I saw another hand. Yes.
Yeah, I'm sorry to ask a question, but I will. Can you give us an approximate idea of the fee structure for all these services?
He won't give you an approximate, he'll give you an exact amount, what it will be, and that'll be in a couple minutes. Yep. Any others?
Yeah, doing it this way, this layout, you're doing the living trust, you don't have a will at all. There's no will.
So good question. So no.
It's still foreign.
Yeah, no, so great question. Within the trust documents, like you said, it's a portfolio of documents. Within it is a will. It's referred to as a pour over will. So think of a cup, pour over will, not pour like you don't have money, pour over will. And essentially it is a document that says, if anything was left in my name, my intention is for it to still go to the same beneficiaries in the same manner. So for an example, my wife had accounts at BB&T, I had accounts at SunTrust. When we got married, we combined everything and then they merged with Truist. It was a whole kind of big deal. Well, we forgot about one account that she had with BB&T that was like a small savings account, a few $100s. What happens if we never put that into our trust? Everything else was in the trust. What happens with that? Our will document would say, hey, anything left in her name goes to our children the same way. And so our kids are still getting it at the age of 25, right? Going into them in equal shares. So when we create this, it kills any other documents, but it does include a will in part of it as well. Yeah.
But if there's, is it possible for anything that's not in the trust to?
Can go to probate. Absolutely.
Correct.
If you have a
So we don't want to
separate-
rely on that, but it's there as an in case for smaller assets, but the goal is having assets in the safe, right? The goal is using it so it's protected. If you put it on top and it says, well, there's a note with it, it's still exposed. So you don't want to rely on it, but it's there as an in case. Yep.
So in this process, we need to spell out all of our assets.
No.
So with sorry,
You're like, wait, is that, hold on, I got this.
so no, so
I want to hear both answers.
that's fine. No, it's going to be the same. So with when you say spelling out the assets, you don't have to go and itemize everything in your home. We do want to make sure we know the property, the real estate, right? Because there's going to be titling with that. When it comes to accounts, financial accounts, he's about to get into what about bank accounts, checking savings, what about retirement accounts? Those are the things that you do want to make sure are attached to the trust, right? You want to make sure that you understand how, and he's about to get into it, so I'm getting a little bit ahead. But when it comes to all the items in your home, you don't have to go through and itemize it. There's a section in here that already does that for you. And so it says all furniture, furnishings, fixtures, appliances, antiques, works of art, coin collections, china, silverware, crystal, books, jewelry, wearing apparel, everything you've bought or will buy is in the trust. Then you get to say who gets what. And so then you can say, well, I have 1 piano and 3 kids. I'm not going to buy 2 more pianos. Somebody's getting the piano, somebody's getting the grandfather clock. And so that's all in there, but you don't have to go through and itemize every time you buy something new.
Awesome. Hey, guys, I'm gonna hold questions at this point so that we're not here till midnight. I've got about 15 more minutes of stuff to get you. I will stop again for questions. You'll be the first one. But let me just move on a little bit for time. Some of the questions will be answered in the next 10 minutes. Thank you. It's taking a little longer, but those were excellent questions. And that was my son, Charles, the one that's going to grab the book. So you're in good hands. That's how he could look at me and go, Dad, stop. All right. I mentioned that trust can distribute as soon as you die. You need a death certificate, access available for assets. I also mentioned the trust can hold assets up to 70 years. Let me give you some practical options that you may or may not want to include. I have a grandson named Caleb. I want to give him $20,000. I write this in the trust. Hey, Caleb, I've set aside $20,000 in the trust. The week that I die, the successor trustee will write you a check. Have fun. Remember, Grandpa, drive careful. There's $20,000, no strings, gift. I could also write that like this. Hey, Caleb, I've set aside $20,000 in the trust for you. In order to get the $20,000 when I die, all you're going to have to do is show the successor trustee a diploma from a college or university with your name on it, or you turned 30, whichever comes first. Now what have I done is I've given my grandson 20,000 reasons not to quit his junior year. I'm not making him go to college. I'm rewarding him for having finished. One lady, that's called an incentive provision. One lady had a different incentive. She had a will only and $300,000, and it was all going through a will to one heir, her son. The problem is her 36-year-old son had been struggling with drugs his entire adult life. Her fear was after probate, he gets $275,000 to spend on drugs. So she puts the money in a trust and writes this. Son, I assume after my death, you're going to want some of this money. Here's how you can get it. The week that I die and every 6 weeks after my death, you will be drug tested. The results will be given to the successor trustee. If those are good results, they will write you a check. If those are bad results, you will hear these words, come back in 6 more weeks with better results. She said, I did not accumulate this wealth to feed your drug dealing friends and your drug habit, and I won't. Isn't that a creative use of the trust for that particular, whether it's gambling or drugs, some issue, you don't want your money to go there. The trust can give you some options. Okay. One lady came to my meeting, said, I have all the reasons to do this. I've seen families fight in probate. I know what that's about. She said, but I have another reason to do this. She said, I happen to have an incredibly lazy son. I don't know what it is. Everybody else got the work, Jane, but he's just happy with a sandwich and playing video games. He's not very motivated. My fear is when I die and he gets more money, he's not going to be more motivated to work. He'll be less. So we wrote this in the trust. Son, after my death, you're going to receive from this trust every year exactly the amount of money that you earned the year before. So if you work part-time at Dunkin' Donuts and make $6,000, $6,000's waiting. If you make $40,000, I'll double your income, but you have to go do something. So the trust allows you to create the rules. How do you want it to all go immediate? You want to put some restrictions? It's all up to you. Last subject, but very important. You have to put assets in the trust. If you don't, it is empty. An empty trust works just like an empty safe. It doesn't work. I did a meeting in Midlothian near Richmond. This lady comes up after, she goes, Daniel, my father had a trust. He paid $3,300 for it. When Dad died, I had to take everything to probate. There was nothing in the name of the trust. He had it made, he signed it, he shoved it in a drawer, but he never transferred title of anything. So it was still the owner. He wasn't a trustee. It all went to probate. I said to her, I don't like to rub salt into your wounds having done that, but it's kind of like your dad bought a really nice safe and then put the jewelry on top. It doesn't matter how strong a safe is if there's nothing in it. It doesn't matter how well written the trust is if there's nothing in it. So assets need to get transferred. So the signing and notarizing of the documents, we then transfer the assets. So we will create the transfer letter telling the county to change the deed. And we will not only do that, but we will, after you sign it, we notarize it, we will take the paperwork to the county for you. So you don't even need to go there. And you will be a trustee the moment we notarize that document. Now, there are things that you have besides real estate. As Charles said, we are going to also help you with the other assets like a checking or savings account. We will pull out the document and say, here's what you show. You got to show the bank that there is a trust, and you will show them this document. Okay, the trust was signed on this date. I'm the trustee. It's the name of the trust. So they will, you're not getting new checks. You're not getting a new debit card. The same accounts are now trust accounts. The bank knows. Good. But you have other assets. So when you're sitting down with us, you might say, but I also have a 401k. Does that go in the trust? And we will say, well, we cannot retitle your IRA or your 401k into the trust today. If we did, the IRS could make you pay all the deferred taxes this year. So we're going to advise you as a client that some assets need to go in and some assets shouldn't go in. IRAs, 401ks, insurance policies, and some government pensions like a TSP, those things would stay in your name. But those things that stay in your name have beneficiaries, meaning it's going somewhere. We will recommend for most of you that you change the beneficiary to the trust. Send it to the trust at your passing. Now, listen, if you're married, of an IRA, your spouse will always be first for tax benefits. Same with the 401k. But the trust should be the contingent, not the children by name. Now, let me tell you why you should do it that way. You don't have to, but let me tell you why. Let's say, for example, the three of you now are my three kids. I'm the father, my wife, your mother has passed. And so I have a $300,000 life insurance policy. They can't see me. A $300,000 life insurance policy, and you are named beneficiaries. Following me so far? I should change it to the trust, but I didn't. And my son and I were going to dinner, car accident, we both die. Where's the money go? To the remaining beneficiaries, 50-50. And I just disinherited his children. Oops. But if I name the trust as the beneficiary, what happens? 300,000 goes to the trust. From the trust, it goes to my three heirs. But the trust says if he's not there, his share goes to his children, not to his sisters. And if his children are young, it won't go till they're 25 because the trust says not at 18. Are you following? The trust knows what I want. And that's how it would go. Now, one more scenario. Don't worry, you all survive this time. Dad, three heirs, $300,000 life insurance policy. I should name the trust, but again, I didn't. And I left you three on there. I died and you each got a check for 100,000. He enjoys the money. She enjoys the money, but you do not. And the reason your sister doesn't enjoy her 100,000, she's in the middle of bankruptcy. Anytime she gets any money, it has to go to the creditors. Not as much fun as the other two. But watch this. If I name the trust as the beneficiary, what happens? 300,000 goes to the trust. The next day, the two of you will go to the bank and get the money and book the cruise or whatever you're going to do. But your sister here in the middle is going to say, I don't want my 100,000 right now. I'm going to leave it in Dad's trust until the bankruptcy's over. And I'll take it in a few years with interest. Or she might say this, I'm not going to take the 100,000 right now. I'm going to leave it in Dad's trust until my divorce is final. Does anybody want 100,000 showing up in your name in the middle of a divorce settlement? Probably not. My point is this gives your children some creditor protection, right? If it shows up at the wrong time, they have the option to let it sit. I'm telling you this point, no one's going to make you change your beneficiaries. We're going to advise you that you should consider it. That is a better option to send it through the trust. But you won't be we will be there to guide you through the process. Let me take a question or two and then we'll wrap it up. This is the end. I will tell you the price, I promise.
Yes, I was thinking about what you said about your grandson, if you are putting some condition for the money. I was wondering about the boundaries, the limit of the reasonability of the request. For example, if you have like a very unreasonable request, like you have to ride a bicycle for 3 years and who's going to decide, legally speaking, what you can write and what it like.
There are laws that allow you to do certain things. You could make your grandson stand on one leg and shout how great grandpa was every year or two before he gets his money. There, you can write some silly stuff, but there are also some rules that you have, the law will decide that, and I'll let the lawyers answer. Those are more specific questions. I do want you to know this, that everyone that works with us speaks to the lawyer and asks all those particulars, and the lawyer can tell you. I will tell you, if I were to put the rule in there, but if you fail the drug test, you don't get the money. What if the son dies or overdoses before that money's distributed? We'll always put in a second contingency. In the event this cannot happen or he doesn't receive, the money goes to this charity church or to the other heirs. We will always put a backup scenario if we put a restriction on. But anyways, anybody else real quick, just for time? Yes. Oh, I promised you, I'm sorry.
I'm curious, you already have a power of attorney, you already have advanced directive and whatever the other one.
Yeah, yeah.
Will, is that somehow included in your trust or is it all gonna be rewritten?
It's all gonna be redone, and there's a reason for that. I could give you the long legal reason. You want it all to be part of the trust. Here's the reason. If you get a power of attorney on its own, it falls under agency law, which means I'm making you an agent for me. If it falls under the trust, it falls under property law. It's much more honored by banks and everything. It makes it a part of the estate plan. It's all combined together. Let me wrap it up with this. Sorry, just for time. I want to get to the end. We'll still be around to answer individual questions, but I want to get to the end. I was doing a meeting down in Fredericksburg. This is a short story, don't worry. And after the meeting, this lady came up and said, Daniel, I know what you're saying is true. She said, my father died with a trust. His house was in it and his accounts were in the trust. And in 2.5 weeks, the money was divided. The house was on the market. Realtors were bringing clients. 2.5 weeks. But she said, my father had another property, a rental property in Fairfax County. He forgot to put in. And she said that property went 22 months in probate before we could sell it. 2 weeks, almost 2 years. What was the difference? One was in the name of the trust and one was in the deceased name. Folks, funding the trust isn't just a good idea. It's what makes it work. We need to get the assets in. Let me just tell you this. Obviously, it's a free workshop. Thank you for inviting everybody here. You can just take the education and do nothing. Feel free to take that. You can find a lawyer on your own and pay whatever they charge. You're welcome to do that. But if you want to work with us, you will get the trust, the wills, the powers of attorney, the advanced directives. You'll get the emergency access card. You'll get the trust. You'll get the flash drive version of the trust so you can share that with family. A lifetime of free phone calls, a year of free changes. For all of this, we charge $3,000. Whether you're married or single, it's to make a trust, it's $3,000. The only additional fee is every piece of real estate that you want us to do the paperwork and the legwork to the county. We do charge $200 per deed to get the deed transferred to the trust. Real quickly, again, no obligation, but for those of you that may go, I need to do this. We've talked about this. This is important. Anybody that chooses to sign up while we're here today, I have applications. We do give a $500 discount, which makes it $2,500. If you have one deed, it's $200 more. Your total would be $27. Let me show you how this works. I would pass out applications. If I see you writing your name on the top, I assume we're going forward today. On the top would be names, then phone number. If you have one deed, we would put a 1. That would be $2,500 plus $200 for the deed. $27 is the total. And then on the next line is, how would you like to pay? You can put it on a credit card or write a check. But let me be extremely clear here. If you do put it on a credit card or write a check, we don't do anything with your money for 7 days. We hold it. We're not charging your card. We're not cashing a check. We want you to have 7 days of don't worry free. You're not on the obligation. You signed up, you got a discount. But if we haven't heard from you by next Wednesday and you haven't called to cancel, we are charging your card next Wednesday. Not today, a week from today. But we're so confident that you're going to like this that if